FAQs on Customs Act 1962, Section 131. Power of revision by central government. Q1. What is Section 131 of the Customs Act 1962 about? Answer. Section 131 gives the central government the power to revise certain orders passed under the Customs Act. Q2. What does revision mean? Answer. Revision means re-examination and correction of an order to ensure it is legal, proper, and just. Q3. Who can exercise revisionary power under Section 131? Answer. The central government exercises this power, usually through a designated authority. Q4. Which orders can be revised under Section 131? Answer. Orders passed by customs officers which are not appealable to the appellate tribunal may be revised under this section. Q5. Can any person apply for revision under Section 131? Answer. Yes. Any person aggrieved by an eligible order may apply to the central government for revision. Q6. Is there a time limit to file a revision application? Answer. Yes. The application must be filed within the prescribed time limit as laid down by rules or notifications. Q7. Can the central government revise an order on its own? Answer. Yes. The central government may suo motu, on its own motion, revise an order if it finds it illegal or improper. Q8. Is an opportunity of hearing given in revision proceedings? Answer. Yes. Principles of natural justice apply, and the affected person is given an opportunity of being heard. Q9. Is Section 131 a charging section? Answer. No. Section 131 is not a charging section. It is a remedial and supervisory provision. Q thus. How is Section 131 different from appeal? Answer. Appeal, heard by an appellate authority on facts and law. Revision, supervisory review to correct legality or propriety. Q11. How is Section 131 linked with other sections? Answer. Section 128/129 Appeals. Section 130 Appeal to High Court. Section 131 Revision by Central Government. Q12. Why is Section 131 important? Answer. It ensures correction of errors where appeal is not available, administrative justice, effective oversight of customs orders. FAQs on Customs Act 1962, Section 132. False declaration, false documents, etc. Q8. What is Section 132 of the Customs Act 1962 about? Answer. Section 132 deals with punishment for making false declarations, statements, or documents in connection with customs matters. Q2. What types of acts are covered under Section 132? Answer. Section 132 applies when a person makes a false declaration or signs or uses false documents or gives false information or statements relating to import, export, or any customs proceeding. Q3 is intention, mens rea, required under Section 132? Answer. Yes. The false declaration or document must be made knowingly or intentionally. Q4. Who can be punished under Section 132? Answer. Any person, including importer or exporter, customs broker, employee or agent, any other person involved in customs procedures. Q5. What is the punishment under Section 132? Answer. Punishment may include imprisonment up to 2 years, or fine, or both imprisonment and fine. Q6. Does Section 132 apply only to goods? Answer: no. It applies to documents, declarations, statements, and information, not just goods. Q7. Can prosecution under Section 132 be launched along with penalty? Answer: yes. Criminal prosecution under Section 132 can be initiated in addition to confiscation of goods, penalty under Sections 112, 114, etc. Q8. Is Section 132 a charging section? Answer: no. Section 132 is not a charging section. It is a criminal offense provision. Q9. Is prior sanction required for prosecution under Section 132? Answer: yes. Prosecution requires previous sanction of the competent authority as prescribed under the Act. Q. Thus, can compounding of offense apply to Section 132? Answer: yes. In appropriate cases, offences under Section 132 may be compounded, subject to rules and conditions. Q11. How is Section 132 linked with other sections? Answer: Section 108 Statements and Evidence. Section 111 बटा 113 Confiscation. Section 112 बटा 114 Penalties. Section 132 False Declarations. Section 135 Serious Customs Offences. Q12. Why is Section 132 important? Answer: it ensures truthfulness in customs declarations, prevents fraud and misrepresentation, strengthens compliance and enforcement. FAQs on Customs Act 1962 Section 133. Obstruction of customs officers. Q8. What is Section 133 of the Customs Act 1962 about? Answer: Section 133 provides punishment for obstructing a customs officer in the lawful discharge of his duties under the Customs Act. Q2. What acts amount to obstruction under Section 133? Answer: obstruction includes preventing or resisting a customs officer, interfering with search, seizure, inspection, or arrest, threatening, assaulting, or using force against a customs officer, creating hindrance in official customs work. Q3. Is physical force necessary to constitute obstruction? Answer: no. Even verbal threats, resistance, or non-cooperation that hampers official duty can amount to obstruction. Q4. Who can be punished under Section 133? Answer: any person who obstructs a customs officer, including importer or exporter, passenger, customs broker, transporter, any other individual. Q5. Is intention, mens rea, required under Section 133? Answer: yes. The obstruction must be intentional or deliberate. Q6. What is the punishment under Section 133? Answer: punishment may include imprisonment up to 6 months, or fine, or both imprisonment and fine. Q7. Can prosecution under Section 133 be initiated along with penalty? Answer: yes. Criminal prosecution under Section 133 can be in addition to penalties or confiscation under other provisions. Q. Art. Is prior sanction required for prosecution under Section 133? Answer. Yes. Prosecution requires previous sanction of the competent authority as prescribed under the Act. Q. No. Is Section 133 a charging section? Answer. No. Section 133 is not a charging section. It is a criminal offence provision. Q. Thus, how is Section 133 linked with other sections? Answer. Section 100, 106 Search and seizure powers. Section 108 Summons and statements. Section 132 False declarations. Section 100 Obstruction of officers. Section 135 Serious customs offences. Q11. Why is Section 133 important? Answer. It protects customs officers while performing duties, ensures smooth enforcement of customs law, acts as a deterrent against interference and violence. FAQs on Customs Act 1962 Section 134. Refusal to be X-rayed or medically examined. Q8. What is Section 134 of the Customs Act 1962 about? Answer. Section 134 provides punishment for refusing to undergo X-ray or medical examination when such examination is lawfully required under the Customs Act. Q. Though, when can Customs require X-ray or medical examination? Answer. When a customs officer has reasonable grounds to suspect that a person has smuggled goods concealed inside the body, as per Section 101. Q13. Who can be punished under Section 134? Answer. Any person who refuses to undergo X-ray or submit to medical examination lawfully required by customs authorities. Q4. Is intention, mens rea, required under Section 134? Answer. Yes. The refusal must be willful or intentional. Q5. What is the punishment under Section 134? Answer. Punishment may include imprisonment up to 6 months or fine or both imprisonment and fine. Q6. Does Section 134 violate personal liberty? Answer. No. Medical examination is allowed only with legal safeguards, and refusal attracts punishment only when the requirement is lawful. Q7. Can force be used to conduct medical examination? Answer. No unsafe force is allowed. Examination must be conducted by a qualified medical practitioner and with due regard to decency and safety. Q8. Is prior sanction required to prosecute under Section 134? Answer. Yes. Previous sanction of the competent authority is required for prosecution. Q. No. Can prosecution under Section 134 be initiated along with other actions? Answer. Yes. It can be initiated in addition to confiscation of goods, penalties, prosecution under other relevant sections. Q. Thus, is Section 134 a charging section? Answer. No. Section 134 is not a charging section. It is a criminal offence provision. Q11. How is Section 134 linked with other sections? Answer. Section 101 Search of suspected persons, internal concealment. Section 132 False declarations. Section 133 Obstruction of customs officers. Section 134 refusal of medical examination. Section 135 Serious Customs Offences. Q. Why is Section 134 important? Answer. It helps detect body concealed smuggling, ensure effective enforcement of customs law, prevent offenders from evading investigation. FAQs on Customs Act 1962 Section 135. Evasion of duty or prohibition, criminal offences and punishment. Q8. What is Section 135 of the Customs Act 1962 about? Answer. Section 135 deals with serious customs offences such as smuggling, evasion of customs duty, and violation of prohibitions, and prescribes criminal punishment for such acts. Q. What types of offences are covered under Section 135? Answer. Offences include smuggling of goods, knowingly evading customs duty, dealing with goods liable to confiscation, fraudulent export or import, attempt or abetment of such offences. Q3. Who can be punished under Section 135? Answer. Any person who is directly involved or knowingly assists or abets the offence. This includes importers, exporters, carriers, customs brokers, and other individuals. Q4. Is mens rea, intention or knowledge, required under Section 135? Answer. Yes. The offence must be committed knowingly or intentionally. Q5. What is the punishment under Section 135? Answer. Punishment depends on the value of goods or duty evaded. Serious offences, value duty above prescribed limit, imprisonment up to 7 years, and fine. Other cases, imprisonment up to 3 years, or fine, or both. Q6. What is meant by specified limit under Section 135? Answer. The monetary threshold, value of goods or duty evaded is prescribed by the government and may change through notification. Q7. Is offence under Section 135 cognizable? Answer. Yes. Serious offences under Section 135 are cognizable, meaning arrest can be made without warrant, as per Section 104. Q8. Is offence under Section 135 bailable? Answer. Serious offences, generally non-bailable. Lesser offences may be bailable. Q9. Can prosecution under Section 135 be launched along with penalty? Answer. Yes. Criminal prosecution under Section 135 is in addition to confiscation of goods, penalties under Sections 112, 114, etc. Q. Thus, is prior sanction required for prosecution under Section 135? Answer. Yes. Previous sanction of the competent authority is mandatory before launching prosecution. Q11. Can offences under Section 135 be compounded? Answer. Yes. Certain offences may be compounded, subject to rules, conditions, and payment of compounding fees. Q12. Is Section 135 a charging section? Answer. No. Section 135 is not a charging section. It is a criminal punishment provision. Q13. How is Section 135 linked with other sections? Answer. Section 104, Power to Arrest. Section 111/113, Confiscation of Goods. Section 112/114, Penalties. Sections 132, 134 other offences. Section 135 serious customs offences. Q14 why is section 135 important? Answer: it acts as a strong deterrent against smuggling, protects government revenue and national security, provides criminal consequences for grave customs violations. FAQs on Customs Act 1962, Section 136. Offences by officers of customs. Q1 what is Section 136 of the Customs Act 1962 about? Answer: Section 136 deals with offences committed by officers of customs while exercising their powers under the Act. Q2 what kind of acts by customs officers are covered under Section 136? Answer: it covers situations where a customs officer knowingly makes a false statement or record, or unlawfully seizes or detains goods, or acts with mala fide intention, or abuses powers conferred under the Customs Act. Q3 why is Section 136 necessary? Answer: it ensures accountability of customs officers and prevents misuse of authority, protecting citizens from arbitrary actions. Q4 is mens rea, intention or knowledge, required under Section 136? Answer: yes. The offence must be committed knowingly or intentionally. Q5 what is the punishment under Section 136? Answer: punishment may include imprisonment up to 6 months, or fine, or both imprisonment and fine. Q6 who can initiate prosecution under Section 136? Answer: prosecution can be initiated only with prior sanction of the central government or the prescribed authority. Q7 does Section 136 apply to honest mistakes by officers? Answer: no. Honest acts done in good faith are protected. Section 136 applies only to willful or malicious acts. Q8 can a customs officer be punished under other laws also? Answer: yes. In addition to Section 136, the officer may also be liable under Indian Penal Code or Service Disciplinary Rules. Q9 is Section 136 a charging section? Answer: no. Section 136 is not a charging section. It is a criminal accountability provision. Q thus, how is Section 136 linked with other sections? Answer: Section 135 offences by persons, smuggling, evasion. Section 136 offences by customs officers. Section 155 protection of action taken in good faith. Q11 why is Section 136 important? Answer: it promotes fairness and transparency, prevents abuse of power, builds public confidence in customs administration. FAQs on Customs Act 1962, Section 137. Cognizance of offences. Q8 what is Section 137 of the Customs Act 1962 about? Answer: Section 137 deals with cognizance of offences, i.e., it lays down who can authorize prosecution and which court can take cognizance of offences under the Customs Act. Q2 what does cognizance of offence mean? Answer: cognizance means the power of a court to take notice of an offence and start legal proceedings. Q3 can a court take cognizance of customs offences on its own? Answer: no. A court cannot take cognizance of an offence under the Customs Act without prior sanction. Q4. Whose sanction is required under Section 137? Answer. Previous sanction of the Principal Commissioner of Customs or prescribed authority is required before prosecution is launched. Q5. Why is prior sanction necessary? Answer. Prior sanction ensures protection against frivolous or malicious prosecution, proper administrative scrutiny before criminal action, fair application of criminal law. Q6. Which court can try offences under the Customs Act? Answer. Offences under the Customs Act are tried by a court of competent criminal jurisdiction, usually magistrate or special court if notified. Q7. Does Section 137 apply to all customs offences? Answer. Yes. It applies, in particular, to offences under Section 132 False Declarations, Section 130 Obstruction of Officers, Section 134 Refusal of Medical Examination, Section 135 Serious Customs Offences, Section 136 Offences by Customs Officers. Q8. Can prosecution be launched without adjudication? Answer. Yes. Criminal prosecution and adjudication are independent. Prosecution can be initiated even if adjudication is pending or completed. Q9. Is Section 137 a charging section? Answer. No. Section 137 is not a charging section. It is a procedural provision relating to prosecution. Q. Thus, how is Section 137 linked with other sections? Answer. Sections 132, 136 offences. Section 137 Sanction and cognizance of offences. Section 138 Presumption of culpable mental state. Q11. Why is Section 137 important? Answer. It ensures controlled and lawful prosecution, protection of individual rights, balance between enforcement and fairness. FAQs on Customs Act 1962, Section 138. Presumption of culpable mental state. Q8. What is Section 138 of the Customs Act 1962 about? Answer. Section 138 provides for a presumption of culpable mental state in certain customs offences. This means the court will presume that the accused had knowledge or intention unless proved otherwise. Q2. What is meant by culpable mental state? Answer. Culpable mental state includes intention, knowledge, belief, reason to believe. Q3. In which cases does Section 138 apply? Answer. Section 138 applies mainly to serious customs offences, especially those under Section 135 Evasion of duty, smuggling, prohibited goods. Other offence sections where mens rea is relevant. Q4. How does Section 138 change the normal rule of law? Answer. Normally, the prosecution must prove mens rea. Under Section 130, the court presumes mens rea and the burden shifts to the accused to prove absence of intention or knowledge. Q5. Is this presumption absolute? Answer. No. The presumption is rebuttable. The accused can disprove it by showing that he acted without knowledge or there was no intention to commit the offence. Q6. What is the standard of proof for rebutting the presumption? Answer. The accused must prove absence of mens rea on a preponderance of probability not beyond reasonable doubt. Q7. Does Section 138 apply to adjudication proceedings? Answer: no. Section 138 mainly applies to criminal prosecution, not to civil adjudication proceedings. Q8. Does Section 138 violate principles of natural justice? Answer: no. Courts have upheld such provisions as valid because the presumption is rebuttable and adequate safeguards exist for the accused. Q9. Is Section 138 a charging section? Answer: no. Section 138 is not a charging section. It is an evidentiary provision. Q. Thus, how is Section 138 linked with other sections? Answer: Sections 132, 136 Customs offences. Section 137 Cognizance of offences. Section 138 Presumption of culpable mental state. Q11. Why is Section 138 important? Answer: it strengthens prosecution in serious smuggling cases, prevents offenders from escaping by claiming lack of intent, acts as a strong deterrent. Key takeaway: under Section 138, mens rea is presumed, and the accused must prove innocence regarding intention or knowledge. FAQs on Customs Act 1962, Section 139. Presumption as to documents in certain cases. Q8. What is Section 139 of the Customs Act 1962 about? Answer: Section 139 creates a legal presumption regarding documents produced or seized under the Customs Act. Q2. What kind of documents are covered under Section 139? Answer: documents such as statements, records, accounts, books, papers, electronic records, produced or seized during customs proceedings. Q3. What presumption is made under Section 139? Answer: the law presumes that the document is genuine and the contents of the document are true, unless the contrary is proved. Q4. Who must disprove the presumption under Section 139? Answer: the person against whom the document is used must prove that the document is not genuine or the contents are false or incorrect. Q5. Does Section 139 apply to documents seized during search? Answer: yes. Documents seized under the Customs Act are presumed to be valid and authentic under this section. Q6. Does Section 139 apply to electronic records? Answer: yes. Electronic records are also covered, subject to provisions of the Information Technology Act. Q7. Is this presumption absolute? Answer: no. The presumption is rebuttable, meaning it can be challenged with proper evidence. Q8. Does Section 139 apply to adjudication proceedings? Answer: yes. It applies to customs adjudication proceedings and also helps in prosecution cases. Q9. Is mens rea relevant under Section 139? Answer: no. Section 139 deals with evidentiary presumption, not intention or knowledge. Q. Thus, is Section 139 a charging section? Answer: no. Section 139 is not a charging section. It is an evidentiary provision. Q11. How is Section 139 linked with other sections? Answer. Section 108 Statements and Documents. Section 138 Presumption of culpable mental state. Section 139 Presumption as to documents. Q12. Why is Section 139 important? Answer. It strengthens evidence collected by customs, prevents easy denial of documents, ensures effective adjudication and prosecution. Key takeaway. Under Section 139, documents seized or produced are presumed to be genuine, and the burden lies on the opposite party to disprove them. FAQs on Customs Act 1962, Section 140. Offences by companies. Q8. What is Section 140 of the Customs Act 1962 about? Answer. Section 140 deals with offences committed by companies and fixes liability on persons in charge of the company when a customs offence is committed. Q2. What does company mean under Section 140? Answer. Company includes a company incorporated under law, a firm, an association of persons, any body corporate. Q3. Who is held responsible when a company commits a customs offence? Answer. Both are liable. The company itself and every person who is in charge of and responsible for the conduct of the business at the time of the offence, e.g., director, partner, manager. Q4. Is every director or officer automatically liable? Answer. No. Only those who were in charge of and responsible for the conduct of business at the time of the offense are liable. Q5. Can a responsible person escape liability? Answer: yes. Such person will not be punished if he proves that the offense was committed without his knowledge or he had exercised all due diligence to prevent the offense. Q6. What if the offense was committed with consent or connivance? Answer: if the offense was committed with the consent, connivance, or neglect of a director, manager, secretary, other officer, then such person is also deemed guilty. Q7. Does Section 140 apply to criminal offences only? Answer: yes. Section 140 mainly applies to criminal prosecution under offence provisions like Sections 132 to 135. Q8. Is mens rea, intention or knowledge, required under Section 140? Answer: mens rea is relevant. Liability depends on knowledge or negligence or failure to exercise due diligence. Q9. Is Section 140 a charging section? Answer: no. Section 140 is not a charging section. It is a vicarious liability provision. Q. Thus, how is Section 140 linked with other sections? Answer: Sections 132, 135 Customs offences. Section 137 Cognizance of offences. Section 138 Presumption of culpable mental state. Section 139 Presumption as to documents. Section 140 Offences by companies. Q11. Why is Section 140 important? Answer: it ensures that companies cannot escape liability by hiding behind corporate structure. Responsible officials are held accountable. Effective enforcement of customs law in corporate offences. Key takeaway: when a company commits a customs offense, both the company and responsible individuals can be prosecuted unless they prove lack of knowledge or due diligence. FAQs on Customs Act 1962, Section 141. Confiscation or penalty, not to interfere with other punishments. Q8. What is Section 141 of the Customs Act 1962 about? Answer: Section 141 clarifies that confiscation of goods or imposition of penalty under the Customs Act does not prevent criminal prosecution or punishment under any other law. Q. Though, what is the main purpose of Section 141? Answer: the purpose is to make it clear that civil action, confiscation penalty, and criminal action, prosecution punishment, can both proceed independently. Q3. Does confiscation of goods bar criminal prosecution? Answer: no. Even if goods are confiscated, the offender can still be prosecuted and punished under the Customs Act and/or any other applicable law, e.g., IPC. Q4. Does payment of penalty prevent prosecution? Answer: no. Payment of penalty does not grant immunity from criminal prosecution. Q5. Can prosecution continue even after adjudication is completed? Answer: yes. Adjudication proceedings and criminal prosecution are independent of each other. Q6. Can a person be punished twice for the same offense? Answer: no double punishment in the same sense. However, confiscation penalty is a civil consequence and imprisonment fine is a criminal consequence. So both can legally coexist. Q7. Does Section 141 violate the principle of double jeopardy? Answer: no. Courts have held that civil penalties and criminal punishment are different in nature. So Section 141 does not violate Article 22 of the Constitution. Q8. Which laws can apply along with the Customs Act? Answer: other laws may include Indian Penal Code (IPC), Foreign Trade Development Regulation Act, any other applicable economic or criminal law. Q9. Is Section 141 a charging section? Answer: no. Section 141 is not a charging section. It is a clarificatory and saving provision. Q. Thus, how is Section 141 linked with other sections? Answer: Sections 111, 125, confiscation and penalties. Sections 132, 100, criminal offences. Section 137, cognizance of offences. Section 141, confiscation penalty, not a bar to prosecution. Q11. Why is Section 141 important? Answer: it ensures strong enforcement of customs law. Offenders cannot escape criminal liability. Clear separation between civil and criminal consequences. Key takeaway: confiscation or penalty under the Customs Act does not protect an offender from criminal prosecution or punishment. FAQs on Customs Act 1962, Section 142. Recovery of sums due to government. Q8. What is Section 142 of the Customs Act 1962 about? Answer: Section 142 provides the mechanism for recovery of money due to the government under the Customs Act, such as duty, penalty, fine, interest, or any other sum. Q2. What kinds of dues can be recovered under Section 142? Answer: recoverable amounts include customs duty, penalty, redemption fine, interest, any other sum payable under the Act. Q3. From whom can the dues be recovered? Answer: from the person liable to pay, including importer or exporter, owner of goods, any person against whom an order has been passed. Q4. What are the modes of recovery under Section 142? Answer: recovery can be made by deduction from any money owed by the government to the defaulter, detention and sale of goods belonging to the defaulter, recovery as arrears of land revenue through the district collector, any other prescribed lawful mode. Q5. Can goods be sold to recover dues? Answer: yes. Goods belonging to the defaulter may be detained and sold, and the sale proceeds are used to recover government dues. Q6. Is prior notice required before recovery? Answer: yes. Recovery action is taken after dues are confirmed by a valid order and the amount has become payable. Q7. Can recovery be made while an appeal is pending? Answer: generally, no, if the amount is stayed by appellate authority or statutory pre-deposit requirements are complied with. Otherwise, recovery may proceed. Q8. Can recovery under Section 142 apply to companies? Answer: yes. Recovery can be made from companies, firms, or individuals as applicable. Q. No. Is Section 142 a charging section? Answer. No. Section 142 is not a charging section. It is a recovery and enforcement provision. Q. Thus, how is Section 142 linked with other sections? Answer. Sections 28/28 are 28 UB, demand and interest. Sections 112/114/117, penalties. Section 125, redemption fine. Section 142, recovery of dues. Q11. Why is Section 142 important? Answer. It ensures effective recovery of government revenue, enforcement of customs orders, prevention of revenue loss due to non-payment. Key takeaway. Section 142 gives customs authorities strong legal powers to recover confirmed dues using multiple recovery methods. FAQs on Customs Act 1962, Section 143. Power to allow import or export on execution of bond. Q8. What is Section 143 of the Customs Act 1962 about? Answer. Section 143 empowers customs authorities to allow import or export of goods subject to execution of a bond with or without security to ensure compliance with customs conditions. Q2. Why is a bond required under Section 143? Answer. A bond is taken to ensure payment of duty or ensure fulfillment of conditions imposed under customs law if the importer-exporter fails to comply later. Q3. When is Section 143 commonly applied? Answer. Section 143 is commonly applied in cases such as provisional assessment, conditional exemptions, warehousing-related clearances, temporary imports-exports, cases where documents or information are pending. Q4. Who executes the bond under Section 143? Answer. The importer, exporter, or any person liable executes the bond in favor of the President of India. Q5. Is furnishing of security mandatory along with the bond? Answer. No. Security may be required with or without the bond, depending on nature of goods, risk involved, discretion of the proper officer. Q6. What happens if the conditions of the bond are violated? Answer. If conditions are violated, the bond can be enforced and duty, penalty, or other dues may be recovered under Section 142. Q7. Can goods be released without bond under Section 143? Answer. Yes, if conditions are already satisfied or the officer considers bond not necessary. Q8. Is Section 143 a charging section? Answer. No. Section 143 is not a charging section. It is a facilitative and procedural provision. Q9. How is Section 143 linked with other sections? Answer. Section 18, provisional assessment. Section 59, warehousing bond. Section 110, provisional release. Section 142, recovery of dues. Section 143, bond for compliance. Q10. Why is Section 143 important? Answer. It provides trade facilitation, flexibility to release goods without delay, safeguards to protect government revenue. Key takeaway. Section 143 allows customs to release goods on bond, balancing ease of trade with revenue protection. FAQs on Customs Act 1962, Section 144. Power to take samples. Q1. What is Section 144 of the Customs Act 1962 about? Answer. Section 144 empowers customs officers to take samples of goods for the purpose of examination, testing, or verification under the Customs Act. Q2. Why are samples taken under Section 144? Answer. Samples are taken to determine classification of goods, value, nature or composition, eligibility for exemption, compliance with import-export conditions. Q3. Who has the power to take samples? Answer. A proper officer of customs is authorized to take samples under this section. Q4. When can samples be taken? Answer. Samples may be taken at the time of import or export, or during examination or investigation of goods. Q5. Is the consent of the importer-exporter required? Answer. No. Consent is not mandatory, but sampling must be done lawfully and fairly. Q6. Are samples taken free of cost? Answer. Generally, samples are taken free of charge, but rules may require payment in certain cases depending on quantity or nature. Q7. Can samples be taken from seized goods? Answer. Yes. Samples can be taken from seized or detained goods for testing or evidence. Q8. Is any procedure to be followed while taking samples? Answer. Yes. Sampling must follow prescribed rules and procedures, ensuring proper sealing, documentation, chain of custody. Q9. Can the test report be used as evidence? Answer. Yes. Test reports based on samples taken under Section 144 are valid evidence in adjudication and prosecution. Q. Thus, is Section 144 a charging section? Answer. No. Section 144 is not a charging section. It is a procedural and investigative provision. Q11. How is Section 144 linked with other sections? Answer. Section 17, Assessment of Duty. Section 18, Provisional Assessment. Section 110, Seizure of Goods. Section 144, Taking of Samples. Q12. Why is Section 144 important? Answer. It ensures accurate assessment of duty, proper classification and valuation, strong evidentiary support in disputes. Key takeaway. Section 144 allows customs authorities to lawfully take samples of goods to ensure correct assessment and enforcement. FAQs on Customs Act 1962, Section 145. Owner of goods to be deemed importer or exporter. Q8. What is Section 145 of the Customs Act 1962 about? Answer. Section 145 provides that the owner of goods shall be deemed to be the importer or exporter for the purposes of the Customs Act unless the contrary is proved. Q2. Why is Section 145 necessary? Answer. It ensures that customs liability does not escape merely because the actual importer or exporter is not clearly identifiable. Q3. Who is treated as importer-exporter under Section 145? Answer. The owner of the goods is treated as importer in case of import or exporter in case of export, unless he proves that someone else is legally responsible. Q4. What is meant by deemed importer or exporter? Answer. It means the law presumes the owner to be responsible for customs compliance, even if he did not physically import or export the goods. Q5. Can the owner avoid liability under Section 145? Answer. Yes. If the owner proves that another person is the actual importer or exporter, liability may shift to that person. Q6. Does Section 145 apply to penalties and confiscation? Answer. Yes. The deemed importer-exporter can be liable to pay duty, subject to penalties, and affected by confiscation proceedings. Q7. Is mens res relevant under Section 145? Answer. No. Section 145 is a legal presumption provision, not dependent on intention. Q8. Is Section 145 a charging section? Answer. No. Section 145 is not a charging section. It is a deeming and liability fixing provision. Q9. How is Section 145 linked with other sections? Answer. Section 2, 26, 27, Importer-Exporter definitions. Section 28, Recovery of duty. Sections 111, 113, Confiscation. Section 145, Deemed Importer-Exporter. Q10. Why is Section 145 important? Answer. It prevents evasion of customs liability, fixes clear responsibility, helps in effective enforcement of customs law. Key takeaway. Under Section 145, the owner of goods is presumed to be the importer or exporter unless he proves otherwise. FAQs on Customs Act 1962, Section 146. Customs brokers, licensing and regulation. Q8. What is Section 146 of the Customs Act 1962 about? Answer. Section 146 provides for the licensing and regulation of customs brokers, earlier called customs house agents, CHA. Q2. Who is a customs broker? Answer. A customs broker is a person licensed under the Customs Act to act on behalf of importers-exporters, prepare and file customs documents, conduct customs clearance work. Q3. Why is a license required under Section 146? Answer. A license ensures that only qualified, trained, and trustworthy persons deal with customs procedures, protecting government revenue, trade interests, national security. Q4. Who grants the customs broker license? Answer. The license is granted by the Principal Commissioner or Commissioner of Customs as prescribed by rules. Q5. Under which rules are customs brokers regulated? Answer. Customs brokers are regulated under the Customs Brokers Licensing Regulations (CBLR) issued under Section 146. Q6. Can anyone act as a customs broker? Answer. No. Only a person holding a valid license under Section 146 can act as a customs broker. Q7. What are the basic obligations of a customs broker? Answer. A customs broker must comply with customs laws and procedures, verify the correctness of documents, advise clients properly, maintain records, avoid aiding smuggling or misdeclaration. Q8. Can a customs broker license be suspended or cancelled? Answer. Yes. The license may be suspended or cancelled for misconduct, violation of regulations, involvement in smuggling or fraud. Q. No. Is personal hearing required before cancelling a license? Answer: yes. Principles of natural justice apply. The broker must be given show cause notice, opportunity of being heard. Q. Thus, can penalties be imposed on customs brokers? Answer: yes. Apart from suspension cancellation, penalties may be imposed under Section 114 बटा 114 and other relevant provisions. Q11. Is Section 146 a charging section? Answer: no. Section 146 is not a charging section. It is a regulatory provision. Q12. How is Section 146 linked with other sections? Answer: Section 2, 19. Definition of customs broker. Section 30/41. Filing of manifests. Section 114 बटा 114A penalties. Section 146 licensing of customs brokers. Q13. Why is Section 146 important? Answer: it ensures professional standards in customs clearance, prevents misuse of customs procedures, strengthens compliance and enforcement. Key takeaway: only a licensed customs broker under Section 146 can legally act on behalf of importers-exporters before customs authorities. FAQs on Customs Act 1962 Section 147. Liability of principal and agent. Q8. What is Section 147 of the Customs Act 1962 about? Answer: Section 147 deals with the liability of a principal and his agent in customs matters. It provides that both principal and agent are liable for acts done under the Customs Act. Q2. Who is a principal and who is an agent under Section 147? Answer: principal, importer, exporter, or owner of goods. Agent: any person acting on behalf of the principal, such as customs broker, employee, authorized representative. Q3. What does Section 147 say about liability? Answer: any act done or omission made by an agent is deemed to be an act or omission of the principal, and both principal and agent are jointly and severally liable. Q4. Does this mean customs can proceed against either principal or agent? Answer: yes. Customs authorities may proceed against the principal or the agent or both, depending on the facts. Q5. Can the principal escape liability by blaming the agent? Answer: no. The principal cannot avoid liability by claiming that the act was done by the agent. Q6. Can the agent also be penalized? Answer: yes. If the agent is knowingly involved in violation or negligence, he can be penalized, prosecuted if applicable. Q7. Does Section 147 apply to customs brokers? Answer: yes. Customs brokers acting as agents fall squarely within Section 147. Q8. Is mens rea, intention, relevant under Section 147? Answer: Section 147 itself is a liability fixing provision. Mens rea becomes relevant under the penalty or offence sections applied along with it. Q9. Is Section 147 a charging section? Answer: no. Section 147 is not a charging section. It is a deeming and liability provision. Q. Thus, how is Section 147 linked with other sections? Answer. Section 112/114/114 are penalties. Section 146 Customs brokers. Section 145 Deemed importer-exporter. Section 147 Principal Agent liability. Q11. Why is Section 147 important? Answer. It ensures accountability in customs transactions. Importers-exporters cannot escape responsibility. Agents act with due care and diligence. Key takeaway. Under Section 147, both principal and agent are legally responsible for customs compliance and violations. FAQs on Customs Act 1962, Section 148. Liability of person in charge of conveyance and agent. Q8. What is Section 148 of the Customs Act 1962 about? Answer. Section 148 fixes liability on the person in charge of a conveyance and his agent for compliance with customs provisions relating to that conveyance. Q2. Who is the person in charge of a conveyance? Answer. It means master of a vessel, pilot in command of an aircraft, driver or person in charge of a vehicle. Q3. Who is considered an agent under Section 148? Answer. An agent includes shipping agent, airline agent, authorized representative, acting on behalf of the person in charge. Q4. What kind of liability is imposed under Section 148? Answer. Any act done or omission made by the agent or the person in charge is deemed to be an act or omission of both, making them jointly and severally liable. Q5. Can customs authorities proceed against only the agent? Answer. Yes. Customs authorities may proceed against the person in charge or the agent or both, depending on the facts. Q6. Can the person in charge escape liability by blaming the agent? Answer. No. The person in charge cannot avoid liability by claiming that the agent committed the violation. Q7. Does Section 148 apply to penalties and prosecution? Answer. Yes. Liability under Section 148 can lead to penalties and prosecution where applicable under relevant sections. Q8. Is mens rea, intention, required under Section 148? Answer. Section 148 itself is a deeming provision. Mens rea is examined under the specific penalty or offense section applied along with it. Q9. Is Section 148 a charging section? Answer. No. Section 148 is not a charging section. It is a liability fixing provision. Q. Thus, how is Section 148 linked with other sections? Answer. Section 30/41 Import and Export Manifests. Section 115 Confiscation of Conveyances. Section 116 Penalty for not accounting for goods. Section 147 Principal and Agent Liability. Section 148 Conveyance and Agent Liability. Q11. Why is Section 148 important? Answer. It ensures accountability in transport operations, proper compliance by carriers and their agents, prevention of evasion by shifting blame. Key takeaway. Under Section 148, Both the person in charge of a conveyance and his agent are jointly responsible for compliance with customs law. FAQs on Customs Act 1962, Section 149. Amendment of Documents. Q1. What is Section 149 of the Customs Act 1962 about? Answer. Section 149 allows amendment of documents such as Bill of Entry, Shipping Bill, Import-Export Manifest after they have been presented to customs subject to conditions. Q2. Why is Section 149 important? Answer. It provides flexibility to correct genuine mistakes, rectify clerical or factual errors, avoid unnecessary litigation. Q3. Which documents can be amended under Section 149? Answer. Documents like Bill of Entry, Shipping Bill, Import Manifest, Export Manifest, any other document presented under the Act. Q4. Who can permit amendment under Section 149? Answer. The proper officer of customs may allow amendment. Q5. Can documents be amended after goods are cleared? Answer. Yes. Amendment is allowed even after clearance, provided the amendment is based on documentary evidence. Such evidence existed at the time of clearance. Q6. Can new documents be produced for amendment? Answer. No. Amendment must be supported by documents that were in existence at the time the original document was filed. Q7. Is amendment a matter of right? Answer. No. Amendment is discretionary, subject to satisfaction of the proper officer. Q8. Can amendment be used to claim a new exemption? Answer. Generally, no, unless conditions were fulfilled at the time of import-export and supporting documents already existed at that time. Q9. Is Section 149 a charging section? Answer. No. Section 149 is not a charging section. It is a procedural facilitation provision. Q thus. How is Section 149 linked with other sections? Answer. Section 17. Assessment of duty. Section 18. Provisional assessment. Section 28. Demand of duty. Section 149. Amendment of documents. Q11. Why is Section 149 important for trade? Answer. It facilitates ease of doing business, allows correction of bona fide errors, reduces disputes and litigation. Key takeaway. Section 149 allows post-filing amendment of customs documents, but only on the basis of pre-existing evidence. FAQs on Customs Act 1962, Section 150. Procedure for sale of goods and application of sale proceeds. Q8. What is Section 150 of the Customs Act 1962 about? Answer. Section 150 lays down the procedure for sale of goods by customs authorities and explains how the sale proceeds are to be applied. Q2. When are goods sold under Section 150? Answer. Goods may be sold when they are confiscated or unclaimed or abandoned or perishable or hazardous or liable to be sold for recovery of government dues. Q3. Who sells the goods under Section 150? Answer. The sale is conducted by customs authorities in the manner prescribed: auction, e-auction, tender, etc. Q4. Is prior notice required before sale of goods? Answer. Yes. Generally, notice is given to the owner before sale, except in cases of perishable goods, dangerous goods, urgent circumstances. Q5. How are sale proceeds applied under Section 150? Answer. Sale proceeds are applied in the following order: expenses of sale, customs duty payable, penalty and other dues payable. Balance, if any, is paid to the owner of goods. Q6. What happens if the owner does not claim the balance amount? Answer. If the balance is not claimed within the prescribed period, it may be credited to the government. Q7. Can goods be sold even if an appeal is pending? Answer. Generally, no, if goods are not perishable and there is a valid stay order. However, perishable or hazardous goods may still be sold. Q8. Is Section 150 a charging section? Answer. No, Section 150 is not a charging section. It is a procedural and disposal provision. Q9. How is Section 150 linked with other sections? Answer. Section 48, unclaimed goods. Section 110/110A, seizure and provisional release. Section 125, redemption fine. Section 142, recovery of dues. Section 150, sale of goods. Q10. Why is Section 150 important? Answer. It ensures timely disposal of goods, recovery of government revenue, prevention of congestion and deterioration of goods at ports. Key takeaway. Section 150 provides a clear mechanism for sale of goods and proper utilization of sale proceeds, balancing revenue recovery and owners' rights. FAQs on Customs Act 1962, Section 151. Central government's power to make rules. Q8. What is Section 151 of the Customs Act 1962 about? Answer. Section 151 empowers the central government to make rules to carry out the provisions of the Customs Act 1962. Q2. Why is Section 151 important? Answer. Because the Act lays down the framework, while detailed procedures are prescribed through rules made under this section. Q3. Who has the power to make rules under Section 151? Answer. The central government has the rule-making power. Q4. What kind of matters can rules be made for? Answer. Rules may be made for matters such as assessment and collection of customs duty, import and export procedures, warehousing, baggage rules, refunds and drawbacks, forms, declarations, and documentation. Any matter required to be prescribed under the Act. Q5. Are rules made under Section 151 legally binding? Answer. Yes. Rules made under Section 151 have statutory force and are binding, provided they are within the scope of the Act. Q6. Can rules override the Customs Act? Answer. No. Rules cannot override or contradict the provisions of the Customs Act. They must be consistent with the Act. Q7. Are rules made under Section 151 published? Answer. Yes. Rules are published in the Official Gazette, making them enforceable. Q8. Can rules be amended or repealed? Answer. Yes. The central government may amend, modify, or repeal rules as required. Q9. Is Section 151 a charging section? Answer. No. Section 151 is not a charging section. It is a delegated legislation provision. Q10. How is Section 151 different from Section 157? Answer. Section 151. Power of central government to make rules. Section 157. Power of Board CBIC to make regulations. Q11. How is Section 151 linked with other sections? Answer. Section 156 Rules to be laid before Parliament. Section 157 Power to make regulations. Section 151 Rule-making power of central government. Q12. Why is Section 151 important for customs administration? Answer. It provides flexibility in administration, ability to update procedures without amending the Act, smooth implementation of customs law. Key takeaway. Section 151 allows the central government to frame detailed rules to effectively implement the Customs Act. FAQs on Customs Act 1962, Section 152. Instructions to Officers of Customs. Q8. What is Section 152 of the Customs Act 1962 about? Answer. Section 152 empowers the Central Board of Indirect Taxes and Customs CBIC to issue instructions, directions, and orders to officers of customs for proper administration of the Act. Q2. Why is Section 152 important? Answer. It ensures uniformity in customs practice, consistent application of law across India, proper guidance to field officers. Q3. Who can issue instructions under Section 152? Answer. The CBIC Board issues instructions, circulars, and directions under this section. Q4. Are officers of customs bound by such instructions? Answer. Yes. Customs officers are bound to follow instructions issued under Section 152. Q5. Can instructions override the Customs Act or rules? Answer. No. Instructions cannot override or contradict the Customs Act, rules made under the Act, judicial decisions. Q6. Can instructions create new liabilities for taxpayers? Answer. No. Instructions are administrative in nature and cannot impose new duties, penalties, or restrictions not provided in law. Q7. Are instructions binding on courts or taxpayers? Answer. Binding on customs officers. Not binding on courts. Generally not binding on taxpayers, but can be relied upon if beneficial. Q8. Are CBIC circulars issued under Section 152? Answer. Yes. CBIC circulars and instructions are issued under the authority of Section 152. Q9. Is Section 152 a charging section? Answer. No. Section 152 is not a charging section. It is an administrative control provision. Q thus. How is Section 152 linked with other sections? Answer. Section 151 Power to make rules. Section 157 Power to make regulations. Section 152 Power to issue instructions. Q11. Why is Section 152 important for trade and officers? Answer. It provides clarity and certainty in procedures, reduction in disputes due to uniform practice, efficient customs administration. Key takeaway. Section 152 allows the CBIC to guide customs officers through binding instructions, ensuring uniform application of customs law. FAQs on Customs Act 1962, Section 153. Service of order, decision, notice, etc. Q8. What is Section 153 of the Customs Act 1962 about? Answer. Section 153 lays down the modes of service of any order, decision, summons, notice, or communication issued under the Customs Act. Q2. Why is Section 153 important? Answer. It ensures that legal communications are properly delivered. Proceedings are valid and enforceable. Disputes about non-service are avoided. Q3. How can documents be served under Section 153? Answer. Documents may be served by tendering personally to the person or his authorized agent. Registered post-speed post courier to last known address. Electronic means email, portal, etc. where prescribed. Affixing at a conspicuous place if other modes fail. Q4. Is electronic service legally valid? Answer. Yes. Service through electronic means is valid if done in the prescribed manner. Q5. When is service by affixation allowed? Answer. Service by affixation is allowed when the person cannot be found or refuses to accept service or other modes of service are not practicable. Q6. On whom can documents be served? Answer. Documents may be served on the person concerned or his agent or authorized representative or a customs broker where applicable. Q7. Is proof of service important? Answer. Yes. Proper proof of service is essential because time limits for appeal start from the date of service. Validity of proceedings depends on it. Q8. What happens if notice is not properly served? Answer. Improper service may make the proceedings invalid or give grounds for appeal or challenge. Q9. Is Section 153 a charging section? Answer. No. Section 153 is not a charging section. It is a procedural provision. Q thus. How is Section 153 linked with other sections? Answer. Section 124 Show cause notice. Section 158/129 Appeals. Time limit depends on service. Section 153 Mode of service of documents. Q11. Why is Section 153 important in practice? Answer. It ensures fair opportunity to parties, proper communication of legal actions, smooth functioning of adjudication and appeal process. Key takeaway. Section 153 prescribes valid and recognized methods of serving customs notices and orders, which is crucial for legality of proceedings. FAQs on Customs Act 1962, Section 154. Correction of clerical errors, etc. Q8. What is Section 154 of the Customs Act 1962 about? Answer. Section 154 allows correction of clerical, arithmetical, or typographical errors in any order, decision, or notice issued under the Customs Act. Q though. What type of errors can be corrected under Section 154? Answer. Errors such as typing mistakes, calculation errors, accidental slips or omissions, clerical mistakes, Q3. Can substantive errors be corrected under Section 154? Answer: no. Section 154 cannot be used to change the substance or merits of an order. It is limited only to minor, apparent mistakes. Q4. Who can correct errors under Section 154? Answer: the same authority that passed the order, decision, or notice may correct the error. Q5. Can correction be made on application by party? Answer: yes. Correction may be made on the authority's own motion or on application by the importer, exporter, or other affected person. Q6. Is there any time limit for correction under Section 154? Answer: no specific time limit is prescribed. However, correction should be made within a reasonable time. Q7. Is personal hearing required before making correction? Answer: generally, no personal hearing is required, since only clerical errors are corrected. However, principles of natural justice apply if correction affects rights. Q8. Can Section 154 be used to reopen an adjudication? Answer: no. Section 154 cannot be used to review, revise, or reopen a concluded adjudication. Q9. Is Section 154 a charging section? Answer: no. Section 154 is not a charging section. It is a procedural rectification provision. Q. Thus, how is Section 154 linked with other sections? Answer: Section 149 Amendment of Documents. Section 128/129 Appeals. Section 153 Service of Orders. Section 154 Correction of Clerical Errors. Q11. Why is Section 154 important? Answer: it allows quick correction of obvious mistakes, prevents unnecessary litigation, ensures accuracy and fairness in customs orders. Key takeaway: Section 154 allows rectification of minor clerical or arithmetic mistakes, but not review or re-adjudication of customs orders. FAQs on Customs Act 1962 Section 155. Protection of action taken in good faith. Q8. What is Section 155 of the Customs Act 1962 about? Answer: Section 155 provides legal protection to customs officers for actions taken in good faith under the Customs Act. Q2. What does good faith mean in Section 155? Answer: good faith means actions taken honestly, without malice or bad intention, while performing official duties under the Act. Q3. Who is protected under Section 155? Answer: protection is given to officers of customs and other persons acting under the authority of the Customs Act. Q4. What kind of protection is provided? Answer: no. Suit, prosecution, or legal proceeding shall lie against such persons for acts done in good faith under the Act. Q5. Does Section 155 protect illegal or malicious acts? Answer: no. Protection does not apply to acts done with malice, without authority, or in abuse of power. Q6. Can a customs officer still be proceeded against for bad faith actions? Answer: yes. If an officer acts maliciously or knowingly illegally, he may be liable under Section 136 IPC or Service Disciplinary Rules. Q7. Does Section 155 bar departmental action? Answer: no. Section 155 only bars civil or criminal proceedings, not departmental or disciplinary action. Q8. Is Section 155 a charging section? Answer: no. Section 155 is not a charging section. It is a protective provision. Q9. How is Section 155 linked with other sections? Answer: Section 136 Offences by customs officers. Section 155 Protection for good faith actions. Q10. Why is Section 155 important? Answer: it ensures officers can perform duties fearlessly, protection from vexatious litigation, balance between authority and accountability. Key takeaway: Section 155 protects customs officers from legal action only when they act honestly and in good faith under the Customs Act. FAQs on Customs Act 1962, Section 157. Power of the Board to make regulations. Q8. What is Section 157 of the Customs Act 1962 about? Answer: Section 157 empowers the Central Board of Indirect Taxes and Customs (CBIC) to make regulations to carry out the purposes of the Customs Act. Q2. How is Section 157 different from Section 151? Answer: Section 151, Central Government makes rules. Section 157, CBIC makes regulations. Rules are broader, while regulations deal with detailed procedures and operational matters. Q3. Who has the power to make regulations under Section 157? Answer: the CBIC Board has the authority to make regulations under this section. Q4. What kind of matters can regulations cover? Answer: regulations may cover procedures for customs clearance, electronic filing and processing, documentation formats, operational procedures for officers, any matter required to be regulated under the Act. Q5. Do regulations made under Section 157 have legal force? Answer: yes. Regulations made under Section 157 have statutory force, provided they are within the scope of the Act and not inconsistent with the Act or rules. Q6. Can regulations override the Customs Act or rules? Answer: no. Regulations cannot override the Customs Act or rules made by the central government. Q7. Are regulations published? Answer: yes. Regulations must be published in the official gazette to become enforceable. Q8. Can regulations be amended or withdrawn? Answer: yes. CBIC may amend, modify, or repeal regulations as required. Q9. Are regulations binding on customs officers? Answer: yes. Customs officers are bound to follow regulations issued under Section 157. Q10. Are regulations binding on taxpayers? Answer: regulations are generally binding, but They cannot impose new liabilities beyond the Act rules. Courts may strike them down if ultra vires. Q11. Is Section 157 a charging section? Answer: no. Section 157 is not a charging section. It is a delegated legislation provision. Q12. How is Section 157 linked with other sections? Answer: Section 151, power to make rules. Section 152, power to issue instructions. Section 157, power to make regulations. Q13. Why is Section 157 important? Answer: it allows efficient and flexible administration of customs law. Quick adaptation to you said 158. ChatGPT said. Here are FAQs, frequently asked questions, on Section 158 of the Customs Act, 1962 explained in simple English, no images. FAQs on Customs Act, 1962, Section 158. Rules and regulations to be laid before Parliament. Q1. What is Section 158 of the Customs Act, 1962 about? Answer: Section 158 provides that all rules and regulations made under the Customs Act must be laid before Parliament. Q2. Why is Section 158 important? Answer: it ensures parliamentary control and oversight over delegated legislation, rules and regulations. Q3. What does laid before Parliament mean? Answer: it means that the rules or regulations are placed before both houses of Parliament for scrutiny. Q4. Which rules and regulations are covered under Section 158? Answer: rules made by the central government under Section 151. Regulations made by the CBIC under Section 157. Q5. For how long are rules regulations laid before Parliament? Answer: they are laid for a total period of 30 days, which may be in one session or in two or more successive sessions. Q6. Can Parliament modify or annul the rules regulations? Answer: yes. If both houses agree, the rule regulation may be modified or it may be annulled. Q7. What happens if rules regulations are modified or annulled? Answer: modified rules apply in the modified form or annulled rules cease to have effect. Actions already taken under them remain valid. Q8. Does Section 158 affect the validity of rules automatically? Answer: no. Rules and regulations remain valid unless modified or annulled by Parliament. Q9. Is Section 158 a charging section? Answer: no. Section 158 is not a charging section. It is a procedural and constitutional safeguard provision. Q. Thus, how is Section 158 linked with other sections? Answer: Section 151, power to make rules. Section 157, power to make regulations. Section 158, parliamentary control over rules regulations. Q11. Why is Section 158 important for democracy? Answer: it ensures transparency in delegated legislation, accountability of executive actions, balance between executive power and legislative control. Key takeaway: Section 158 ensures that rules and regulations under the Customs Act are subject to parliamentary scrutiny, maintaining democratic oversight. FAQs on Customs Act 1962, Section 159. Protection of action taken under rules or regulations. Q8. What is Section 159 of the Customs Act 1962 about? Answer: Section 159 provides legal protection for actions taken under rules or regulations, even if such rules or regulations are later modified or annulled by Parliament. Q though, why is Section 159 necessary? Answer. It ensures that actions already taken under valid rules regulations are not invalidated retrospectively. This protects administrative certainty and stability. Q3. What kind of actions are protected under Section 159? Answer. Actions such as assessments, collections of duty, clearances, procedures followed, done in good faith under rules or regulations. Q4. What happens if a rule or regulation is annulled by Parliament? Answer. The rule regulation ceases to have effect prospectively, but actions already taken remain valid under Section 159. Q5. Does Section 159 protect illegal actions? Answer. No. Protection applies only to actions taken lawfully and in accordance with the rules regulations as they existed at that time. Q6. Does Section 159 apply to both rules and regulations? Answer. Yes. It applies to rules made under Section 151 and regulations made under Section 157. Q7. Is Section 159 a charging section? Answer. No. Section 159 is not a charging section. It is a saving and protective provision. Q8. Can past actions be challenged after annulment of rules? Answer. Generally, no, if actions were taken lawfully and before annulment or modification. Q9. How is Section 159 linked with other sections? Answer. Section 151 Rule Making Power, Section 157 Regulation Making Power, Section 158 Laying before Parliament, Section 159 Protection of Past Actions. Q thus. Why is Section 159 important? Answer. It ensures continuity of administration, protection against retrospective invalidation, legal certainty for trade and customs authorities. Key takeaway. Section 159 safeguards past actions taken under customs rules or regulations, even if those rules are later changed or annulled. FAQs on Customs Act 1962, Section 160. Repeal and savings. Q8. What is Section 160 of the Customs Act 1962 about? Answer. Section 160 deals with repeal of earlier customs laws and provides savings for actions taken under those repealed laws. Q though. Which law is repealed by Section 160? Answer. Section 160 repeals the Sea Customs Act 1878 and other corresponding customs laws that were in force before the Customs Act 1962. Q3. What does repeal mean? Answer. Repeal means that the old law ceases to have effect from the date the new law comes into force. Q4. What is meant by saving under Section 160? Answer. Saving means that certain actions taken under the repealed law remain valid, even after repeal. Q5. What kinds of actions are saved under Section 160? Answer. Actions such as notifications, rules, orders, appointments, licenses, proceedings done under the old law are deemed to have been done under the Customs Act 1962 if consistent with it. Q6. Are pending proceedings under old law affected? Answer. No. Pending proceedings continue as if the old law had not been repealed unless otherwise provided. Q7. Does Section 160 protect rights and liabilities created under old law? Answer. Yes. rights, obligations, penalties, or liabilities incurred under the repealed law are not wiped out by repeal. Q Art. Why Section 160 important? Answer. It ensures smooth transition from old customs laws to the new Act. No disruption in administration. Legal certainty and continuity. Q No. Is Section 160 a charging section? Answer. No. Section 160 is not a charging section. It is a transitional and saving provision. Q Thus. How is Section 160 linked with other sections? Answer. Section 158, 159, Parliamentary Control and Savings. Section 160, Repeal and Savings, final provision of the Act. Key takeaway. Section 160 repeals old customs laws but protects past actions, rights, and proceedings, ensuring continuity under the Customs Act 1962. Subscribe for regular updates and expert content. Knowledge grows when you subscribe. Subscribe to learn something new every day.